Good afternoon, everyone, or good morning, good afternoon, whatever part of the world you're in. And thank you very much for being uh, here in this by the Court of Appeal of the DIFC. We are here to discuss the case between the sorry, just if you allow me. Can you hear me well?
Yes, we
Hello?
can. Yes, we can.
Okay. We are here for the appeal from the Digital Economy Court between Laith Piney, which I believe you are representing, and please confirm that, and Mr. Raz or Mrs. Raz Rani, the respondent, with regards to the dispute on their transaction over the platform of Clivity. So good afternoon, and I will start by giving the floor to the counsel for the appellant to please state your arguments and your submission with regards to the case. Please, you have the floor, Mr. Chima.
Thank you, Your Excellency. Once more, good afternoon, Your Excellency. Your Excellency, I am the Senior Appellant Counsel. My name is B.C. Chima. Chima, I've already spelled it on the chat box, on the said chat box on this Zoom platform. Your Excellency, the appellant filed an appellant's bundle. It is dated and it was filed on the 4th of November 2022. In it, we raised two grounds. There are two grounds which were raised. Whether the first instance court has the jurisdiction to entertain the claim of Ms. Razrani, and secondly, whether a reasonable person would have concluded that the said dispute contract was reached as a result of an error. Your Excellency, we provided arguments for this in the said appellant's bundle, and particularly at page 7, paragraph 29 of the appellant's bundle, we made reliefs, we sought for reliefs and prayers, and their reliefs and prayers contained there. With the kind permission of this court, we rely on all arguments contained in the said appellant's bundle, and we pray that this court resolve both grounds in favor of the appellant and grant specifically the prayers as contained in paragraph 29 of the said appellant bundle. Now, Your Excellency, with your kind permission, I will now adumbrate on grounds 1. Why, when I'm done, I'm going to defer proceeding to my learned co-counsel, which is the junior appellant counsel, to adumbrate on grounds 2. Your Excellency, for the purpose of timing, we are aware we have 45 minutes before this honorable court. I will use 20 minutes. The junior appellant counsel will use 20 minutes, and we choose to reserve 5 minutes for the rebuttals, despite the fact that, unfortunately, the respondent counsel are unable to make it, but we reserve 5 minutes for the rebuttal in case they are able to make it. So, Your Excellency, with your kind permission, I would like to proceed with the grounds 1.
Go ahead. Please proceed.
Thank you, Your Excellency. Your Excellencies, on ground 1 has to do with whether the first instance court had the jurisdiction to entertain the claims of Ms. Razrani. And it is the submission of the appellant counsel that the first instance court did not have the requisite jurisdiction pursuant to Article 5A sub 1B of the Judicial Authority Law to entertain the claim of the respondent claimant at the first instance court. Your Excellency, to buttress our submission, we shall be relying on 2 standpoints. The first standpoint is that the parties did not operate from the DIFC jurisdiction, they did not operate within and from the DIFC. And secondly, is that there is no proof that a server or the node that is in the DIFC was used for the consummation of the said dispute contract. Your Excellency, with your kind permission, I shall now begin with the first standpoint. And the first standpoint is that the party did not operate from the DIFC, did not operate from and within the DIFC. Your Excellency, Council shall be placing reliance on statutory authorities as well as judicial authorities. Firstly, Council shall be placing reliance on Article 5A sub 1B of the Judicial Authority Law. Further, Council shall place reliance on the case of Al Khurafi and Bank Saracen. Your Excellency, this is a decision of this Honorable Court. Further, Council shall be placing reliance on the case of Lucian and Latori. Your Excellency, Lucian and Latori. And we shall place reliance also on the case of Gavin and Geno. Gavin and Geno, Your Excellency. And we provided the citation for these authorities at paragraph 4, paragraph 5, and paragraph 6 of the Appellant's bond. Your Excellency, we humbly direct the mind of this court to paragraph 4, paragraph 5, and paragraph 6, where we have provided the authorities and the court's decisions in these said cases. Your Excellency, it is the jurisprudence of this court. It is the position of the law that the DIFC court will have jurisdiction where the parties who are before it have transacted within the DIFC. It therefore means that if parties before this court have not transacted within the DIFC, within the jurisdiction of the DIFC, then the DIFC court cannot exercise jurisdiction over either of the said parties. This was affirmed by the decisions by the statutory authority and the decisions I mentioned earlier. Your Excellency, Council shall now direct the mind of this Honorable Court to paragraph 3 of the case fact. Your Excellency, I direct the mind of this court to paragraph 3 of the case fact. In paragraph 3, we are made aware that Lit Payne and Ms. Razrani do not reside within the DIFC. Your Excellency, Mr. Payne resides in the Sultanate of Oman, and Ms. Razrani resides in the Dubai, UAE. And the case fact made mention specifically that this is not within the DIFC jurisdiction. Your Excellency, premised on this, we are making our submission submissions pursuant to Article 5A sub 1B that being that Ms. Razrani and Mr. Payne did not operate, or neither did they live within the DIFC jurisdiction. This Honorable Court does not have the jurisdiction to entertain the claims of Ms. Razrani. Your Excellency, further, we direct the mind of this court to paragraph 7 of the case fact. We very much understand and we acknowledge the fact that Clevity has a node within the DIFC. However, Your Excellency, the relevant question that needs to be asked is Clevity a party to this suit? Your Excellency, Clevity is not a party to this suit. As can be seen in the processes, there are only 2 parties before this Honorable Court. And the party's name is Mr. Payne and Razrani. These are the parties before the suit. Clevity, who has a node and operates within the DIFC, is not before this court. And it is premised on this that we are submitting that Clevity, who is not before this court cannot utilize because there was a node within the DIFC of Clevity to decide whether this court has jurisdiction over the claimant. The relevant question is the claimant and the respondent, which is Lit Payne and Ms. Razrani, do not reside within the DIFC and they did not operate from the DIFC. It is premised on this that we are submitting on this standpoint that the parties did not operate from the DIFC and this court does not have jurisdiction to entertain the claims of the claimant. That the first instance court did not have the jurisdiction to entertain the claims of the claimant and the first instance court erred. Moving on to the second standpoint, Your Excellency, I shall begin with the second standpoint now. The second standpoint is that there is no proof, Your Excellency, there is no proof that the server or the node based in the DIFC was utilized for the conclusion of the said dispute trade. There is no proof it was utilized. We acknowledge the fact that Clevity has a node. However, there is no proof that this said node was used for the conclusion of the said dispute contract. Your Excellency, we shall be placing reliance on Article 5A sub 1B again of the Judicial Authority Law. Your Excellency, Judicial Authority Law. We are placing reliance on Article 5A sub 1B. Also, we are placing reliance on the case of Al Khurafi and Bank Saracen. Al Khurafi and Bank Saracen. Your Excellency, it is the jurisprudence of this court it is the position of the law as established by this statutory authority and the cases that where it can be shown that the said commercial activity consummated either wholly or in part within the DIFC jurisdiction, then the DIFC court may exercise jurisdiction over a dispute that has arisen. Your Excellency, I now direct the mind of this court to paragraph 1 of the case facts. Your Excellency, paragraph 1 of the case facts, it is stated that Clevity has a node within the DIFC. However, Your Excellency, the relevant question that needs to be asked is, was this said server, was this said node, was it used for the consummation of the said contract? Your Excellency, the answer is no, because there is nowhere it is stated in the Moot problem, the Moot fact that the said node or the said server was used for consuming the dispute contract. It's premised on this that we are submitting that being that there is no proof that this said node was used for the consummation of the said contract, it does not satisfy Article 5A sub 1B of the Judicial Authority Law. Further, Your Excellency, we also premised our argument on the fact that the node that was in DIFC, was not used for the consummation of the said contract because it could be that it was a node that was in China that was used for the consummation of the said contract. It could be that it was a node in Nigeria that was used for the consummation of the said contract. It could also be that it was a node, a server in the United States of America that was used for the consummation of the said contract. Being that there is no proof that was a node or a server that occurred that is in the jurisdiction that was used for the said contract, it is therefore a submission that this does not have been shown, so that the first instance court, the digital economic court, did not have the shown when it entertained the claim of the respondent claimant, that is Ms. Razrani. And Your Excellency, we submit and pray finally, direct the mind of this court to paragraph 29 of the Appellant bundle that one, this court should hold that first instance court erred. It reached an error when it held that in court that it had jurisdiction over the claims of Ms. Razrani. Your Excellency, this is the humble submission of the Senior Appellant Counsel before this honorable court. Your Excellency, we are very much grateful.
Thank you very much, Chima, for your submission and for your clear argument representing the appellant for this case. We're hoping that the respondent actually join us because this would have been.
Yeah. Sorry for interrupting. The respondents are not responding to our calls. So once the appellant is done, then we'll end this room.
Okay. So in all cases, we will continue with the flow without the respondent, and maybe we will try to do it differently. So we will start with the senior counsel from the appellant, and then the junior counsel from the appellant. And then probably I'm going to also make some points after each one of them, and then if the respondent join us at some point, then they will follow the same order, and then we'll probably have some time for rebuttal and further comments. Having mentioned that, I would like to just, before we give the floor to the junior counsel, if you allow me, I would like to ask some questions here for clarification, Mr. Bisi Chima. So, thank you. First one is just trying to understand better your understanding of applying the jurisdiction of the DIFC. You are basing it on the people that are within the jurisdiction. I mean, within that they are parties with the DIFC or registered with the DIFC. But when you have a platform does it matter anymore in your understanding when you have a platform and this platform is under the jurisdiction of the DIFC? Does it matter anymore the users of the platform in your understanding, or also the users of the platform has to be basically registered with DIFC?
Thank you very much, Your Excellency, for that question. That question is a wonderful one, and it actually buttresses the point of the appellant further. Your Excellency, in the case of Al-Khurafi and Bank Saracen, particularly at paragraph 64 of the said judgment, it was stated by the court that when it comes to deciding the jurisdiction of the first instance court, it is relevant that the proper parties are before the Honorable Court. Your Excellency, it was stated that if the parties operate from within the DIFC, then the DIFC has jurisdiction. Your Excellency, even if other requirements are satisfied, but the requirement as to parties is not satisfied, the first instance court cannot have jurisdiction. That is the position of the law. This particular position was reiterated in the case of Gavin and Geno. In the case of Gavin and Geno, that position was reiterated. Also, in the case of Lucien and Latour, is a decision. Lucien and Latour is a decision of the DIFC court. That's the small, though it's a decision of the small claims tribunal. However, in these decisions, it was reached that the parties is a requirement that must be satisfied. And if parties is not satisfied, then the first instance court cannot have jurisdiction. Your Excellency, this is the submission of the Appellant Counsel regarding the said question. If you need me to make more clarification, I'm very more than happy to do that.
Okay. So just to make sure I understand you, you're understanding that the platform that it operates according to the DIFC still does not make the jurisdiction of the DIFC applicable to the people using that platform. Can you just confirm?
Yes,
if
Your
I
Excellency.
understand? That's your understanding. Okay.
Yes,
so you need
yes,
two
yes,
levels.
yes, Your
Level
Excellency.
the platform is under the jurisdiction of the DIFC, and then the people themselves should be within the DIFC. That's your understanding.
Yeah, yes, Your Excellency. Your Excellency, even further, even if Clarity just has a node in the DIFC jurisdiction, just a single node, but not, Clarity is not a party to this suit. To further buttress that particular point, it is not a party. If it were a party to this suit, that would have been a different case. But it's not even a party. And another thing, the parties have not reached an express agreement that when a dispute arises, that it will be referred to the DIFC court. There's no agreement as to such, because Gavin and Geno, the court allowed an exercise jurisdiction because the parties have expressly donated powers to the DIFC court to exercise jurisdiction. But in this instant case, there is no express power given the DIFC court to exercise jurisdiction. Secondly, the Clarity platform, which has a note in the DIFC, is not a party to this suit. Your Excellency, it is premised on this that we are submitting that the first instance court erred when it exercised jurisdiction over the claims of Ms. Razrani.
Okay, I have another clarification here since you talked about it, is related to Clivity is not part of this appeal. Is there a clear indication in your view that I don't know, maybe the appellant in your case, since you're representing the appellant, that he sees Clivity is not party at all of this dispute? But is it the same understanding of the respondent? I mean, having the first dispute not talking about Clivity possible, but does not prevent, in my understanding, does not prevent the respondent from basically also referring to Clivity as being part of this dispute. Do you have a legal argument that prevents the respondent of claiming such argument that clevity should also be part of this dispute eventually, or has to do with this dispute eventually?
Yes, Your Excellency. Premised on parties satisfying the jurisdiction requirement of this court, the respondent will not be able to lay claim to being that a node or the server of clevities in the DIFC, then DIFC's research jurisdiction. The respondent will not be able to do this because clevity itself needs to be a party. A court, the jurisdiction of a court, yes, for emphasis, the jurisdiction of a court is determined by the parties that are before it. Who are the parties before this honorable court? The parties before this honorable court is Razrani and Late Spain. These are two persons who do not reside within the DIFC. Your Excellency, so the respondent cannot make an allusion or make an argument as regards clevity. We are premising our argument on the case of Gavin and Geno. Your Excellency, this case of Gavin and Geno is a very notorious case. It's a notorious case that establishes, that emphasizes the fact that parties needs to be, that proper parties need to be before the court. Or not just the case of Akrafi is very instrumental in this respect because Akrafi's case dealt on the proper parties that are before the court. And not just that, the case of Lucian and Latoury. In Lucian and Latoury, the court emphasized that the DIFC court will have the fourth jurisdiction where the parties who are within the DIFC jurisdiction are before the court. But in this case, the only two persons who are before this court do not reside within the DIFC. Your Excellency, it is premised on this that we are making our submissions.
Okay. Another question I have is that you are saying that there is no proof that the server or the node is within the DIFC. How you make such an argument saying that there is no proof?
No, Your Excellency. Okay.
Of a node?
Yes, Your Excellency. Your Excellency, we acknowledge that clevity has a node in the DIFC platform. This is stated in paragraph 1 of the case fact. I seek your leave to read. It states, one such node is on a server based within the DIFC. In the Moot problem paragraph 1, it is stated there, 1, 2, 3, 4, 5. Lines 5, it is stated in lines 5, Your Excellency. We acknowledge that it has a node. However, our argument is that there is no proof that this said node was used in the consummation of the said contract. It could as well be that a node in the United Kingdom was used for consummating a transaction. It could also be that a node in China was utilized. Being that there is no proof to show that the node within the DIFC was used for consummating this contract, there is no way this court can ascertain that it was the said node within the DIFC that was used. Your Excellency, this is our passionate submission before this honorable court, and we are seriously praying that the first instance court heard and this honorable court should rule and give judgment in favor of the appellant.
Okay. Another question I have, but maybe I could wait for your junior counsel, and then I could probably see if I still have that question. So back to you, Mr. Chema, if you would like to introduce your junior counsel and probably, he could start his statement and his further arguments related to the case.
Thank you, Excellency. We'll allow proceedings to him.
Yes, please, Mr. Igbonovia, if you would like to.
Thank you, Your Excellency.
Please.
My name is Ignovia P, the Junior Appellate Counsel representing the appellant in this case before this Honorable Court, Your Excellency. With your kind permission, Counsel would like to enter into the substance of his argument.
Please proceed. Thank you.
Thank you, Excellency. Your Excellency, Counsel shall be canvassing on grounds. Counsel shall be canvassing arguments on grounds 2 that has been distilled for determination before this Honorable Court. Grounds 2 poses the question whether the first instance court was in error when it concluded that for the purpose of a claim to avoid disputed trade, for the purpose of satisfying at the sub 1 of the DIFC contract law of 2004, that Ms. Razi, the respondent, showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the dispute trade was the result of an error. On this ground, Your Lordship, Your Excellency, it is Counsel's humble submission that indeed the first instant court's conclusion that Article 37, Sub 1, Paragraph A of the DIFC contract law of 2004 was satisfied simply because it could be shown and established that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the trade was the result of an error was grossly erroneous and does not reflect the true position of the law. Your Excellency, Counsel's argument is predicated upon 3 strong pillars. The first pillar is that, based on the circumstances surrounding this case, the provisions of Article 37, Sub 1, Paragraph A, which is the law that governs the subject matter in this appeal, was not satisfied, cannot be applied, because the conditions necessary for its application were not satisfied, Your Excellency. Grounds 2 is to the effect that the error that was made in this case was made by the respondent. It was a unilateral mistake, which was negligent, and that pursuant to Article 37, Sub 2, Paragraph A and B of the DIFC contract law, these do not serve as a valid ground for the avoidance of the contract between the appellant and the respondent. The third and final standpoint upon which Counsel's argument is predicated upon is that the first instance court was wrong to have relied on the dissenting judgment of a foreign court as its rationale for its judgment. At this junction, Your Excellency, Counsel would like to proceed into the substance of his argument. Your Excellency, it is pertinent to state the following things. First, that the applicable law that governs the subject matter on this ground is the DIFC law, the DIFC contract law of 2004. And that in order to do a just and valid determination of this ground, at all times, reference should be made only to the provisions of the DIFC contract law, as it is the law that governs the subject matter in this ground of appeal. Moving on to the first pillar upon which Counsel's argument is predicated upon, it is submitted that Article 37, Sub 1, Paragraph A of the DIFC contract law of 2004 cannot be applied because the conditions necessary for its applications have not been satisfied in this instant case. Your Lordship, based on the provisions of Article 37, Sub 1, the conditions that have been distilled that needs to be satisfied before it can be applied are: 1, that there is a mistaken party on the one hand, and on the other hand, that the other party either made the same mistake or caused the mistake or knew or ought to have known of the mistake such that it was contrary to reasonable standards of fair dealing to leave the other mistaken party in error. Your Excellency, the purpose of this provision is very simple and straightforward, and it is that in order for the provisions of Article 37 to be applied, firstly, there must be a mistaken party. And secondly, the other party must have made the mistake or must have caused the mistake or must have known or ought to have known of the mistake during their dealings in the course of making a contract, Your Excellency. And it is Counsel's humble submission, after a thorough, holistic, and comprehensive perusal of its made of facts, that nowhere was it stated, Your Excellency, nowhere was it contained that the appellant in this case made the mistake, caused the mistake, or ought to have known of the mistake that the respondent is basing is basing its case upon for it to be avoided. Your Excellency, Counsel would like to have read the minds of this court to paragraph 7, the statement of facts, which states that when Ms. Razi discovered what had happened, she issued proceedings in the DIFC Court, Digital Economic Court, seeking a declaration that the disputed trade was void for unilateral mistake. Your Excellency, unilateral mistake is a mistake that was made by a party. Is a mistake that was made by the party, and based on the provisions of this statement of facts, clearly it is stated that it was only the respondent that was mistaken, and thus this means that the conditions necessary for the applications of Article 37 sub 1 were not satisfied, and as a result, it is strongly submitted that Article 37 sub 1 cannot be applied in this case on the grounds that the necessary conditions were not satisfied. Your Excellency, on the second pillar of Counsel's argument, Counsel shall be relying on the provisions of Article 37 sub 2, which provides that I seek your kind permission, Your Excellency, to read the provisions of Article 37 sub 2 of the DIFC law contracts of 2004.
Thank you very much. Please.
Thank you, Your Excellency. Article 37 sub 2 of the DIFC contract law of 2004 provides that, however, a party may not avoid the contract if A, it was grossly negligent in committing the mistake, or B, the mistake relates to a matter in regard to which the risk or mistake was assumed, or having regard to the circumstances should be borne by the mistaken party. Your Excellency, the purport, the object, and the purpose of this provision is to the effect that where it is found that only a party to a proceeding made a unilateral mistake, which was negligent at best, in doing so, coupled with the fact that the risk of this mistake was assumed by the party in question, the law is that will not serve as a valid ground for avoiding the contract. Your Excellency, reference is made to paragraph 7 and paragraph 8 of its statement of fact, which to the effect that the respondent, Ms. Razi, admitted that she made a mistake while programming Alpha to buy Yapol at the best possible price. Also, Your Lordship, she stated that if she had known, Alpha would not have been programmed to buy Yapol at the best available price. Your Lordship, this statement, as can be found in paragraph 7 and paragraph 8 of the statement of fact, clearly shows that the mistake that is alleged in the instant case was a unilateral mistake, which was negligent on the part of the respondent. And based on the provision of Article 37 sub 2 of the DIFC law contract law of 2004, this does not serve as a valid ground for the avoidance of the contract between the respondent and the appellant. It is submitted upon this premise, Your Excellency, that Article 37 sub 2 has made the mistake that was committed by the respondent not to be a valid ground for the avoidance of this contract. Moving on to the third pillar, Your Lordship, Your Excellency, it is Counsel's submission that the first instance court was wrong to have relied on a dissenting opinion in the case of Queen and B2C Limited on the following grounds. One, that firstly, a dissenting opinion is regarded in law as an aside that has no legal importance or binding effect whatsoever. Secondly, reference to that case was material, simply because there was a provision in the DIFC law contracts law of 2004, specifically Article 37 sub 1, which governs the law that regulates the circumstances under which a mistake would have been committed by parties. And that amounted to a deviation from the provisions of Article 37 sub 1 when the first instance court went ahead to rely on a dissenting judgment that was provided by a foreign court in the case of Queen and B2C, in the case of Queen and B2C2. Your Excellency, on this grant, it is submitted that reliance on a dissenting opinion in Queen's case was grossly erroneous, as not only is it a dissenting opinion without any legal importance or binding effects, it is also contrary to the laws on the subject matter, as provided in Article 37, Sub 1 of the DIFC law, Your Excellency. Owing to the argument proffered before the Honorable Court by counsel, it is finally submitted, Your Lordship, that indeed the First Instance Court erred grossly when it held that Article 37, Sub 1 was satisfied, merely because the respondent was able to show that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error, on the grounds that, one, the conditions necessary for the application of Article 37 were not satisfied. Secondly, that the respondent made a unilateral mistake, which pursuant to Article 37 Sub 2 does not qualify as a valid ground for avoiding the contract. And thirdly, that reliance on a dissenting judgment in the case of Queen and B2C2 was in case of Benin and B2C2 was grossly wrong, as does not reflect the true position of the law on this subject matter. Counsel thus prays the Honorable Court to so hold and resolve this ground of appeal in the appellant's favor. Thank you, Excellency.
Thank you very much for your statement and for your argument. I have a question. If you can help me and clarify.
Of course, Your Excellency.
You talked in your intervention and argument that Mr. Rani was prepared, and not only him, but also you. But I'm going to focus on Mr. Rani. I mean, you can, of course, speak in behalf of the appellant, but of course, in behalf of the respondent. It's I just want to know your understanding. Do you assume that the respondent was, when we say he's prepared, that he's prepared also in case the platform has a glitch or has a problem? Is that part of your understanding of preparedness, that your program should also be ready in case there is a problem with the platform itself? Is that part of your understanding of preparedness?
Thank you, Excellency, for this question. Your Excellency, the contract between the appellant and respondent was concluded on a digital network, and it is commonplace for digital network to have glitches every now and then. Also, this contract was consummated by an algorithm program that was programmed beforehand, giving instructions by the respective parties, by the appellant and respondent, meaning that at the point in time where when this program was made, they already knew what they wanted. Your Excellency, counsel would like to make reference to paragraph 4 of its made of facts. Paragraph 4 states that Ms. Razi's program, who is the respondent, is called Alpha. She programmed Alpha to automatically buy a cryptocurrency called Yapol at the best possible price available on the Clarity platform. Your Excellency, at the best possible price available on the Clarity platform. It is my submission that at the time the contract was concluded, the price at which the respondent bought Yapol, the cryptocurrency in this case, was the best possible price available on the platform, which was in line with the instructions that she gave to our program. Also, the appellant's program, which was called Beta, was programmed or was coded in such a way to sell Yapol on the platform at a price based on the average price for Yapol. Your Excellency, this clearly shows that both parties, prior to coding the program, had already contemplated what they would like to expect and get from the contract making. So, Your Excellency, it is my submission that the contract between both parties, the appellant and the respondent, was concluded in line with the instructions that they gave to their respective programs, Your Excellency.
Okay. Thank you.
Thank you, Your Excellency.
Thank you for your clarification. I I have no further comments to make with regards to the case. I was hoping that the respondent would attend with us, but it seems not to be the case. I now pass it to the senior counsel or yourself in case you would like to make your final comments and rebuttal, if any.
Thank you, Excellency.
So,
At this
yes.
point, I will defer proceedings to my senior appellant counsel for his final comments in this case. We are grateful, Your Excellency.
Noted. Thank you. Please, Mr. Chino, if you'd like to make your conclusion as well as rebuttal, if any, with regards to your argument representing the appellant for this case.
Okay. Your Excellency, I'm sorry, may I be guided? What do you mean by comments, sir? Please, I want to be guided. I'm sorry.
I think you have made an intervention, with your arguments, and then of course followed by your colleagues. In between, I was asking some questions. Of course, I'm not here representing any of the parties, but I had some general clarifications and understanding. You mentioned as many points, of course, in your intervention as well as from your colleague, but now, just in case you want to make being the senior counsel specifically, if you wanted to make a final wrap up of this argument, or you want to stop where your colleague stopped, taking into account some of the clarifications that were raised by myself, the judge of the case.
Thank you very much, Your Excellency. We want to reemphasize the fact that the first instance court erred. It did not reach a just decision procedurally. The decision it reached is procedurally defective when it chose to exercise jurisdiction over the claims of the respondent claimant, Your Excellency, and we premised our argument on the fact that the parties did not operate from within the DIFC, and also on the fact that there is no proof that the server in the DIFC was utilized, and that the server or the node in the DIFC was utilized for the consummation of the said contract. Importantly, Your Excellency, further, we want to direct the mind of this honorable court to paragraph 29 of the appellant's bond, Your Excellency, and we seek the following reliefs: that one, a declaration that the first instance court erred in jurisdiction in holding that it has jurisdiction over the dispute trade. And secondly, we are seeking a prayer we are seeking a declaration that the first instance court erred in holding that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the dispute trade was the result of an error. And further, we sought a declaration that the dispute trade is valid and subsisting. And lastly, we sought the declaration for any other declarations and orders that this court may deem fit to make. Your Excellency, in essence, we are stating that this court resolve the two grounds in favor of the appellant. We are graciously obliged, Your Excellency. Thank you very much for the audience.
Thank you. Okay, so with this session and round is adjourned in terms of the case. However, I could switch hat now, and if you allow me, talk to you as an outsider looking at the session, if you like to say your argument. So this is now not part of the respond for me as a judge, but actually as if you allow me, as an advisor or supporter. I have some viewpoints. You might want to take them into account or not. But I want to start by saying well done, honestly. You guys have done a great job. I've seen other teams as well today. I was judging other sessions as well. But your team definitely stands out. So well done. You guys are doing great. I really liked the energy. I liked the teamwork. I liked your professionalism in the presentation. I like your, in general, your style of persuasiveness and how you used different, authorities and different legal facts and so on. I only have few things that you may wish to think about them. It's your choice how you would like to move forward later on with the other sessions when you have other rounds, hopefully, if you get that chance. I hope to see you even in the final, I don't know. But to make it to the point, I think a few points just to think about. One is to support your argument with more technical understanding of the situation. You don't have to go deep at all, but you just need to understand the concept of a node and a server. In general, node means that you have a technical components that this transaction is needed to happen, or in general, it's a required part for the ledger, the distributed ledger, to work. So your argument that there is no proof of a server, you might want to think about it. It's just up to you if you would like to think about this. I'm not sure if it's very solid argument. So that's more of a technical thing, but it has an impact on your legal argument. And since you're talking about blockchain, it's called blockchain because it's a chain. So and having a node within that chain, yeah, just not sure if that the argument of a server, you need to prove it to me if it's here or not, given that they tell you that the node is part of this ledger and it is part of this operation and transaction. I think it's or this Clivity platform has a clear node and it's a blockchain technology, it's a distributed ledger. That's usually somehow gives a, so that's just one thought. It's and I don't know if you don't believe, if you don't like any of my comments, that's okay, absolutely fine. Maybe I'm wrong, but that's how I see it, just as an individual. And the other thoughts just to think about is it was related to one of the questions that I had about, does that jurisdiction is only bound by people who are registered with DIFC or physically placed within DIFC, or as if you have a platform that is under the jurisdictions of the DIFC, then it doesn't matter who's using that platform. It's really now becomes independent of the people. I don't know, members could be from any part of the world using the platform, as far as the platform transaction has something that is under the jurisdiction of the DIFC. So I'm not sure. Would I keep emphasizing the idea of the people, where they are located, or I will keep emphasizing on whether the platform is under the jurisdiction or not? It's just a thought, again, because so many of the platforms that we're using today in the virtual world, they have people using them from different parts of the world, right? Whether it's in the social media or it's in the blockchain and so on. And it becomes now a matter of where this platform is being licensed, or which jurisdiction is applicable to that platform rather than the people where they are located. So it's just something to think about. Maybe, as I mentioned, maybe you find it useful. Another point is where else? I mean, it's if DIFC doesn't have a jurisdictions, where do you see the jurisdiction is applicable? Who has the jurisdiction? So some people, some people that could propose alternatives, but you basically answer. I mean, you give an argument to half of the issue, which is saying that DIFC doesn't have a jurisdiction, but who has it? Who could have it? Not one, could be one. Like, and as an example, who could be, as an example, have such a jurisdiction more than here or something like that? So this is another thing. And then the other part, and this is probably the last technical comment, I've spoken about the most of my comments. The first ones were about your management of the situation, which is I like. Then my second comments were related to the technicalities of your argument. And again, this is just a thought to think about, and you like any of it, make use. If you don't like any of it, that's absolutely fine. You are here to present yourself and your thoughts and your belief. But one point, just probably think about it, and I hope to really see you in the in the final rounds and potential winner. I don't know, let's see. But it's about having Clivity not liable at all and not part of the mistake at all. It's probably you want to think this is that the case if there is a glitch in the software because something wrong happened to at least someone is claiming something wrong happened, and then there is a clear fact that there is a glitch with the software that has made some mistake, and someone is operating that, and he's saying there is something wrong that happened, so these algorithms, they have instructions bound with some criteria, and if something happens around the environment of this criteria, it could affect such programs. So the point would be is, of course, to think about do I necessarily saying that there is no one mistaken except the respondent, and we don't even believe that the respondent is mistaken by accident or something like that. So I think keeping the door opens to other type of innovative solutions. It could be, I don't know, the respondent take it with the Clivity if he wants. All what we want to say is us. We did not do a mistake. Someone else did a mistake. It's not our fault. Something like that. So that's just another thoughts as well. But again, these are just thoughts in general. I think it's a great work. Your submission is a little bit long, but your performance in the oral is great. And yeah, all the best. Sorry if I said something not what you wish to hear or anything, but I mean the best.
Thank you very much. I appreciate.
Most welcome. All right, so I just think I had someone from the host with us. If you'd like to indicate to us, you can just join the session, or
yeah, we can join the session now.
Okay. Thank you
very
very much.
Thank you, Judge.
Thank you, guys. All the best. Wish you all the best in your in this, of course, competition, but in general, and you're fantastic. Thank you. Take care.